Right. Good morning. Hey,
Morning,
Liam.
mate. How's it going?
Yeah, good. Good. Yourself?
Well, thank you.
I just like saying this because I think it sounds cool. Just trying to get my levels right, get our levels right, man.
Right, yeah. Make sure you're not crushing the EQ.
Um, so without further ado, guys, we're gonna do in the next week or so because everyone's got. I think I've just lost Liam, but that's okay. I'll have to go solo soldier for a little while. Here he is. He's back.
Apologies.
Technical difficulties.
Yeah.
Much more something I would be akin to usually.
Yeah,
So
no,
enjoy it. That you'll
my
actually
bad. As you
get,
were.
get one back. It's all good. So we're just doing, given everyone's got plenty of time on their hands,
Mm.
other than essential workers, going to do a 5 session rundown for entrepreneurs about from the very beginning, from the inception stage when they come up with an idea right through to actually running the company. So the first thing we're going to talk about is when you have that idea stage. So Liam, when would be the best time? At what point would you want to start thinking about some of the more practical aspects of starting your own business or starting your own venture while still employed? At what point would you want to start making lists of all the practicalities and advisors such as lawyers, accountants, industry insiders, so to speak, friends who have done it themselves? At what point would you want to get all of that going? How long? 3 months, 6 months, 9 months? Once you've had the idea, how from your anecdotal experience of seeing our clients, the ones who have done it and successfully succeeded?
Yeah. Well, I mean, in my experience, the ones I've worked on, it's really taken probably about 6 months from sort of start to finish for them to kind of really start that process of this is what I'm doing now, and then to actually sort of get an end product and sort of begin trading. So working with that time frame, I would probably say maybe 9 months as a very sort of generous buffer period of sort of saying, all right, I've gone from having an idea to this is what I'm wanting to focus on. And in about 9 months, you can sort of see yourself, maybe less, but to say 9 to be comfortable. But that's sort of, I think, the sort of time frame you can expect to sort of end up going from that sort of germinating idea to a trading company, or at least hopefully trading.
I would agree with that. I think it takes. So the message out there to everyone watching is it takes longer than you think, and all these supposed overnight success stories, they may have got frustrated with being employed. They may have just it had been not for them, and it takes longer, that period of frustration slash motivation to get in and actually do something off your own bat. It takes a lot longer than people think. I would say 9 months, maybe even 12 or 15 or 18 months. But I think the message is once you've got to the point where you've decided that's what you want to do and you've got a clear idea of what that looks like, you've got to pull the trigger. You've got to just whether that means resigning from your current job if you've got enough, if you're lucky, or you've been smart enough to have got into a position where you've got enough runway in terms of cash flow to actually finance it yourself, or maybe you've got some friends and family who will be generous enough to invest in you. Although that's a topic for itself later in the week. You've got to get out there and pull that trigger as well. And pulling the trigger looks different for everyone. I mean, Gary Vee talks a lot about not wanting to, about being practical about things. So it's all very well to sort of go, oh, I'm going to go out there and take over the world and quit my $150,000 a year job. Well, it might not be that wise until you've actually been able to do a lot of the gestation period of the idea to the point where you're actually able to trading in your own time after hours, because it may be a better thing. But it's always particular to a person's circumstances.
Yeah, no, 100%, 100%. And you definitely just want to pull that trigger, because then you'll sort of often, you may sort of end up kind of compromising both your current job and the actual idea you're trying to sort of turn. It takes a lot of skill, dedication to actually turn this idea into an actual living, breathing concept. And not only really the most sort of tenacious people are those people who can sort of work 9 to 5, go home, and then work pretty much another 9 to 5 in the night to then actually bring that idea to life. So it's really just making sure you come to that point where you're saying, okay, this is what I do, and now I'm going to focus on that. And as you said, that's either maybe leaving your job if you have enough cash runway. But then in a way, it also helps you avoid any kind of potential sort of sticky situations. I think we've seen a couple where some people have been trying to sort of focus on this idea, and then maybe an employer might catch wind of it or something like that. And then it just sort of allows a sort of potential kind of conflict to arise. So you always just want to make sure you're nice and clear, because you don't want to start off your sort of journey, which is already hard enough as it is, with a bit of a complication like that.
That was a great segue, Liam, into the whole area of restraints of trade. Now, restraints of trade under an employment agreement, you can be restrained from many different things. You can be restrained from using proprietary information obtained during the course of your employment in furtherance of another commercial venture. You can be restrained from soliciting clients, even if you introduce them to your existing employer. You can be restrained from taking them with you. You can be restrained, of course, from taking staff members or suppliers with you. There's a whole breadth of restraints that you would need formal legal advice about if you were thinking about breaching that restraint of trade. Now, I kind of get the feeling with restraints, Liam, that there are two really polar schools of thought or theories with how you deal with them. One is the rip, shit, and bust, she'll be right, sort of glamorized, sort of watching Silicon Valley on Netflix. She'll be right. We'll just get a good lawyer. And then the other one is just to be in total trepidation of your lawyer or of your employer with big resources, or a lot more resources than you anyway, with a really good lawyer to come after you and to really tiptoe around. Now, I think the truth is somewhere in between, and it requires an actual a particular specific analysis of the restraint in your contract and some practicalities. For example, I was involved with and Liam knows about this, a hospitality business I'm a shareholder in, where we decided to be pretty cavalier about the restraint. And it turned out that once we got some advice from a real top flight barrister dealing with the practicalities of it, is that it was sufficiently grey that this gentleman would have got an interim restraint, which would have meant that we would have, at the very least, be fronting up 15 to 20K for a good barrister trying to argue that. And there's a good chance we would have lost and at least had paid costs until they had a substantive hearing. That wasn't an employment contract. That was under a sale and purchase of business contract. But the same principle applies with employment contracts, in the sense that if that employer has a lot more resource than you, they can go after you, and just the cost alone of defending any kind of allegation of breach of restraint of trade can sink people, or at very least cause them significant distress, and it's not the mindset you want to be going in to start a new venture. And that's why employers in that situation, in that position, will do that.
Yeah, particularly because, not always, but often, these people who are leaving to start their own journey, more often than not, it's sort of a tweak on the business they're currently in. Not often is it a complete kind of pivot into a different area. They're sort of seeing something in the company or in the industry that they're currently in and saying, oh, this is actually what I think, or really I would do it this way. So then you're kind of actually going on a sort of, taking a left turn, but you're still on the sort of same path. So you're kind of, you'll still possibly be interacting in that industry with your former employer. And so depending on how you actually interact with them, that's also another consideration for how much or how likely they might go after you. If you're sort of really just kind of going to be eating into their market, or at least incorporating similar elements in your business model, they'll probably be more liable to go after you than if you just did a complete pivot into a different thing.
So what Liam's saying there is that, just to break it down a little bit further, is the proximity your new venture has, objectively viewed, or as objectively viewed as possible, to the former venture or the former company you're working for. If you were working in IT and you decide to go start up a trucking company, sorry, I'm on a 24-hour water fast and 72-hour water fast, 24 hours into it, and I think I'm doing all right though. I'm still upright. If you're starting a trucking company and you were in IT, there's not really that much plausibility to the IT company going after you. If you're starting another IT company, of course, and then there's everything in between, isn't there?
Yeah, 100%.
Just another one. If you're giving up on something and you're going to go and, like in the case of talking about my colleague and my business partner selling a bar and getting into the food and grocery industry, and then we had a conversation and it was along the lines of, I'm not worried about the restraint because I'm never going back. Well, now he is back in that industry. This is when he sold a business. So also you just need to have a little bit of you need to take a little bit of care and get good advice, because if it's no water, if it's no skin off the nose of the person who's going to grant you something like, for example, a more reasonable restraint when you're leaving a job or leaving a business, you might as well take that, because you never know what you're going to do in the future. So you also want to be on that level. I know it's a bit of a side point, but you got to negotiate as hard as you can from an objective sort of maximizing your position perspective at any given time, because you never know what will happen in the future.
Yeah, no, 100%.
Okay, so that's the restraints covered off. That's the idea stage, and you start talking to people like ourselves and accountants. So Liam, do you want to just run the viewers through just quickly what the incorporating a company process looks like?
Yeah, so I mean, I guess just taking a step back, a company is definitely the most often vehicle used for the ideas and whatnot, as opposed to sort of going into partnerships. But yeah, company incorporation is
sole trader as well.
Yeah, sole trader. Company incorporation is actually a relatively straightforward process. It's really done all through the company's office, which is online, and anyone can do it. It involves basically coming up with a name, reserving it. I think that's about $45 plus GIST. And then it's once that name's accepted by the company's office, which means it's not a name too similar to someone else's, basically, then you can go through with incorporating it. And so that involves signing just a director's certificate saying that you're not disqualified from being a director. So that would be something like if you're being convicted for certain offences, or there's certain bankruptcies. You're a director of a former company that's gone insolvent recently. Those are all sort of reasons which could disqualify you, but more often than not, it's all fine. So that's really, again, just submitting a document to the company's office, and then it becomes registered. Through that process, you're asked if you want to register for an IRD number and GST number. Now, if you're intending to trade relatively soon, that makes sense.
Even if you're not intending to trade, Liam, you want to get the company GST registered as soon as possible, because everything you buy, you will be claiming GST on.
That's the thing, yeah. But my only caveat to that was then just be prepared if you are going to be GST registered. That therefore means you're going to have to start doing GST returns and stuff, which for the uninitiated can sometimes be pretty daunting. So you want to be sure that you either have an accountant, or I know, in fact, one of my friends, she's trying to incorporate a company at the moment now, and I just sort of said, before you become GST registered, just make sure, you either have an accountant, or there's actually companies these days which you can almost just engage with, and then they just make sure that all your GST is sorted and GST returns are filed on time. Again, obviously there'll be a fee paid to them, but you'll want to make sure that that's all sorted before, because as I'm sure many current business owners can attest to, if the GST starts getting out of control, it's not a pretty place to be in.
Yeah. So, what Liam's saying there is, if you're not actually going to be buying a whole lot of business related items, that you can claim the GST portion as an expense. Claim it as refundable or input credit for GST, when which you'd get that money back. The downside of the admin and cost and stress of having to manage the GST, if this thing isn't actually full noise, is actually outweighs any benefit of actually being able to claim the GST. But once you get to the point, so that's at the real inception stage. Once you get to the point when you're buying computers and entering into leases and all sorts of other, software subscriptions and paying for website developers and all that sort of stuff, you might have a bill of 50K, even for a little business. Now that's $7,500 you're going to get back in GST. So most people would want that back, but it all depends, like Liam says, where you're at in the spectrum or where you're at in terms of the stage of incorporating a company or starting a business.
And then just the last thing really is with incorporating a company is it offers a chance to upload a constitution. And now a constitution is something that you'll be familiar with because you likely would have engaged lawyers or at least talked to lawyers at this point, and you would have told them that you're going to be incorporating a company or at least intend to, and they would, well, any lawyer with a salt would probably bring up at this stage whether it's worth having a constitution. And that's simply a document which you upload on the company's office, and it just basically regulates how that company is to be run vis-a-vis how if you were to bring on shareholders later down the line, but it's also just if shares to be sold or setting out anything to do with the shares and how that.
Careful too if you're selling shares, your shares or transferring shares, and there's a change above 50% of the total share capital of the company, that will invalidate any ability to bring forward what accountants call bring forward losses. So you have losses incurred in a tax year and you want to bring them forward to the next year. If the shareholder changes by 51% or more, that will invalidate that. So get advice around incorporation in the company from a lawyer accountant. And if you go to change anything with that company in terms of the shareholding, you need to make sure you think about that, because a lot of companies will start with losses in the first year or two, particularly if they're even more medium scale companies, and you need to make sure. And who we're really talking to here are much more, one-man bands, people starting out with an idea, as opposed to someone who's already on their feet and has a competent lawyer and accountant. They'll cover all that for you. So it's really aimed at you people out there that may be quite talented, entrepreneurial, you may be in the professions, you may be, have a great idea, and you just need to go and listen to videos like this and get as much advice as you can around these sort of little traps for young players, so to speak.
And I guess and it's always sort of related to the constitution. It depends, as you said, whether usually it's a sole person who's come to us or any lawyer starting up a company. But sometimes they already have an investor with an idea, or it's just two parties. Then a thing called a shareholders agreement, which I think we'll do a video on just in and of itself, could be worth considering. And that's usually dealt with when you deal with the constitution. Now, the shareholders agreement, it basically is a document which, if there's two or more shareholders, we highly recommend you enter into, because that basically regulates how the company is actually going to be run between shareholders. So that's, for example, if you want to bring in more people down the line, or if someone wants to leave, it sets out all these just rights, duties. And it's a really important document, so we highly recommend you look at that video.
That's awesome. That's great, Liam. And also, the shareholders agreement, of course, is a private document between shareholders. Constitution is publicly registered, so anyone can search that. So the more private affairs of companies will always be in a shareholders agreement as opposed to a constitution. And there's some, like Liam said, we'll do a video perhaps tomorrow, because we're going to keep these nice and, we hope, pithy and short. In terms of our advice, is that it's a constitution. Sorry, I'll start again. You have the Companies Act, which is the Companies Act 1993, that sets out essentially the codified law around, and there is some obviously common law as well that surrounds that, the decisions of judges and whatnot. But you've got the codified Companies Act, which is like a code for how everyone needs to abide by in terms of how they operate their company. And then under a constitution, you can modify some of that or opt in or opt out, and we'll get into that in more detail. Liam's the man for that tomorrow. Then the shareholders agreement is a even more particularized structure on top of that. So you've got Companies Act, you've got the constitution, then the shareholders agreement. They all work in concert together, and you need the issue with getting a lawyer, an accountant, or lo and behold yourself to put that all together without professional input it can be tricky to navigate or understand what parts of each document need to work in concert together so that the effect is not contradictory. So the very thing you're trying to determine, for example, whether or not one of the shareholders can actually go and sell their shares to a third party that you have no prior knowledge of or haven't even met, believe it or not, you can do that. So someone needs to advise you on what the documentation looks like to actually be able to effect that, whatever you guys have agreed. So getting around the table with your lawyers, sitting down, we do it all the time with other parties and their lawyers, and we have a really robust, frank discussion about everyone's expectations, and then we document everything off in all those documents, make sure the clients understand and the other parties understand, exactly what's been agreed, and then everyone walks away. And that process in and of itself is incredibly valuable because everyone has had that discussion. And another thing what Liam's just been looking at, and I actually went and read the wrong decision because I'm a numpty. The what was the name of the case, Liam? Bathurst.
Bathurst and L&M. Yeah.
So we'll do a little video on that in the next few days or next week or so as well. But that case highlights the importance of, or the primacy, as the judge called it, of the contracts. And then there is, as well, regard has to be had to the level of record keeping around the negotiations and what the parties actually intended clauses to mean. Because some things, no matter how much you try and make them black and white in a contract, can't be determined in an absolutely crystal clear way. And that a judge would read in other evidence, even third-party evidence, as to what the parties intended when a contract was put together. That's a technical subject for another day, but it's just another interesting thing to think of how precise you need to be when you're in this area.
Yeah. No, agree.
All right, team. Thank you very much for tuning in. We're going to be doing these every day, and the whole concept behind it is the journey between starting out, having the idea, talking to people about the idea, doing a bit of research, and then thinking I could actually make this a viable trading entity and make some money out of this. And that's where we want to make it nice and linear and temporal, in a temporal sense, to say you're at the very, very beginning. What do I do? What are the sort of things I need to talk about? So today we covered off the idea stage, restraint to trade under employment agreements, and a little bit under sale and purchase of business agreements, the process of incorporating a company, and then how the Companies Act, Constitution and Shareholders Agreement can work in concert to set out the parameters from which you need to operate. So we hope that's added a little bit of value for you guys, and we look forward to seeing you again, same bat time, same bat channel tomorrow. Cheers.
Awesome. Cheers, mate. Thank you.
Thank you, mate.